Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is time set for oral argument, and you're going to have to help me on some names here as we go along, all right? But Giglio versus Mirshahzadeh, our case number, and I'm happy to be corrected at the appropriate time, our case number is CV220458. Each side is allocated 20 minutes for oral argument. If appellant wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium. Out of respect for counsel and to avoid any embarrassment, I would ask those in attendance to make sure your cell phones are off so our proceedings are not interrupted. We've read the briefs. We have conferenced the case. We're familiar with the record, and we encourage you to keep that in mind in your presentation today. Our proceedings are being recorded, and so I would ask, and will be posted to YouTube at the appropriate time, and I would ask when you present that you start by telling us your name and the party or parties that you represent. With that, Mr. Meyer, you may proceed.
Good morning. Yes, my name is Ross Meyer from Willencheck & Partners, and I represent Mike Mirshahzadeh.
Thank you.
But that is correct. The names in our office on this case have a couple nicknames that make it easier. But so in this case, we're essentially presented with a paradox where Mike Mirshahzadeh, the appellant, had entered into a company as a member. The members amended the operating agreement to specifically provide that if the company has losses or profits, they get the benefit of that. And if there's a loss, they get to elect whether they want to personally take those losses, which would be a normal procedure that happens in an LLC. Then, about a month later, the members are presented with this special allocation agreement that says, hey, if you want to take your losses, you have to agree to this $155,000 loan that the company took, and you have to have personal liability on it. And the problem with that is it creates this paradox where the members have already contributed capital to the company, and now they're put in a position where I either have to sign this and accept it, or I lose the ability to claim my losses that I've already contributed. And there's not anything new that's provided to any of the members because they were already able to claim those losses.
Okay, so let me ask, we have a world where we have the First Amendment and the Second Amendment, and then we have the special allocation agreement. And it is that last document that you claim is not enforceable because it's not supported by consideration and doesn't have certainty of terms, right? That's kind of why we're here. Tell me what the world looks like if that agreement never existed. What could your client just claim everything, something, we're not sure? Tell me what that world looks like.
So let me make sure, if the special allocation agreement just didn't exist.
Exactly.
Right. What that world would look like is the appellee would be able to claim the loss for the loan he provided to Legacy, the full amount of that, and secondly, each of the members would be able to claim the losses of their capital contributions to Legacy. And so that would be the action there.
But in sort of in specifics, because for the 2016 tax year, what could your client, because we know kind of with the special allocation agreement, if you follow that, what the percentage is, but would that percentage be different if the special allocation agreement didn't exist?
Oh, I see what you're saying.
Yeah.
Okay, so I'm not sure exactly the math, but what it would be made up of is my client's capital contribution of $65,000, which is, for reference, it's on app 252. It's a deposition transcript at lines 8 through 10. And also the tax returns, I assume those were sent to your offices. They were sealed at the Superior Court. But
I believe they're part of the record,
Okay,
but in
good.
sealed
Yeah,
form.
and so those are there. My client's 2016 tax returns, he had other losses claimed in other entities, so he moved those to 2017 as a rollover, but under that scenario, his losses would be his capital contribution and then losses of the company, but not losses of the company related to the loan.
But as I understand it, his ownership interest and his ability to claim under the special allocation agreement were a little different, right? The ownership interest in percentage-wise?
Yes.
Does that, and that's what makes me wonder if maybe the special allocation agreement did some work, that your client got something that he might not have otherwise gotten, and others gave up something that they might not have had to do, and that seems pretty close to consideration. And that's,
Let me say this without admitting that's consideration, but I see that argument, but here's the problem.
and I'm happy to have you take it away from that word, although that's why we're here.
And so here's the way that works. And it's almost, I have two arguments for that. First, we have the Second Amendment, which says they can do this. And that's what provided the right to do it. The action of electing to do it isn't changing that they have the right to accept that. So if member, I think it was Christensen, although I could be wrong, I believe Christensen rejected the special allocation agreement. But
That's consistent with my
right.
notes, but
Okay.
yeah.
And so, so there, that has nothing to do with my client. I mean, while he receives a benefit from it in the sense that her membership interest is allocated between other people, that's not part of the allocation, that's not a part of a term of the allocation agreement. It's more a function of the Second Amendment to the operating agreement, and that all the members were able to choose whether they want to participate or not.
So there's no difference in the rights after the Second Amendment. It seems don't the consenting parties get a share of the non-consenting party that they otherwise wouldn't have had?
Right.
And so if that's correct, isn't that a consideration? And my hazy memory of law school as a consideration is pretty much anything you can conceive of.
You are correct on that. And so let me present.
Well, and if I'm correct on that, and I'm not 100% saying I am, but if I am correct on that, then if that's consideration, then that seems to be what your claim is missing, and that's the end of the argument, as I see it.
Well, under that line of argument, it would be if all the members accepted the allocation agreement, then there would be no consideration. And so it doesn't really follow, because the act of choosing isn't the consideration. If none of the members except for my client chose it, my client would be able to accept 100% of the company's losses, but that's not, he's not doing anything for that. Instead, he's electing his own choice based on what the Second Amended Operating Agreement said. And I think the further, so to my second point, and the additional problem with this, and as it's characterized in the answering brief, is the position these members were put in is accept this debt that you're not liable for right now, or lose all your capital contribution losses that you could otherwise deduct. And so these members are put in this situation where they have to say, yes, I want this, if they have significant capital contributions there. And so the argument presented is look, they either accept this and take their losses, or they don't take any losses and until the members recoup 200%.
That strikes me, though, as edging toward an argument that's different than failure of consideration, and that's that along with certainty of terms are the two that I think are in front of us. So another way, I suppose, of looking at it is, yes, you had to personally obligate some debt, or you were on the hook for some debt in the second or special allocation agreement, but you also got more either benefit or deduction than you had a right to as a percentage of your ownership interest, because I think it went from 20 to 25 for your client.
Correct.
And so help me, and I understand your thought is, well, there was no guarantee that was going to happen, and I hear what you're saying on that, and you talked about Christian, I think, Rebecca Christian, not participating in that. But that possibility didn't happen.
So, yeah, and it's a hypothetical.
And hypotheticals are okay. I don't mean, it's just...
No, it's not the facts that are here.
Right.
So the question is then, or the answer is, the special allocation agreement was presented to each of the members. And each member has one choice based on the second operating agreement, accept or reject. And it's for the losses of the company. There was no ability to simply do that, to simply accept their losses or reject their losses. Instead, that was tied in with this loan, with this personal liability. And so under that framework, I think if we said, look, there's a special allocation agreement of the 2016 losses, do you want to accept or reject? I don't think we'd be arguing that it's not a new contract, it's more just a simple LLC taking action based on their operating agreement of what they have to do each tax year.
But isn't that hypothetical more the paradigm of where consideration may be lacking, as opposed to, here one way to look at it is your client undertook an additional obligation and got an additional benefit. That's one way of looking at how it came out. But whereas when you're talking about simply allocating, what would your client be giving up?
So simply allocating, if my client accepted it,
without the debt obligation.
Without the debt, he's already entitled to do that, is the point. And so he would be accepting his capital contribution losses and whatever losses the company had of his percentage, but would also be entitled to take the percentage of any member that elected not to do it. And so our argument is that he already has this. If any member elects not to, he already has that ability. And so electing to do that doesn't change that ability. And the Superior Court made issue of one thing that wasn't before the court as an issue raised by the parties, and that's this looking back, whether the allocation agreement was able to be applied to the 2016 tax year. I'm sorry, whether the second amended operating agreement was able to be applied to the second 2016 tax year, sorry. The problem with that is Legacy had not filed their taxes in 2017. At that point, in the record, in those sealed exhibits, you see that the company's accountant mailed out the tax forms to the individuals in late July of 2017, and then our client filed his taxes in October of 2017. And so they were in the middle of the process of doing the 2016. And so I wanted to make that point. And if that were raised in the Superior Court, we would have addressed that. Let me see. I mean, this is the heart of the issue, is what the consideration is. And I think our second argument is that swapping tax liabilities, it isn't, it doesn't change an at-risk basis, because it's, they're essentially serving no purpose. And so that's another issue that we raised at the lower court and here.
And help me out, because I understood your primary argument, at least, to be fair consideration under Arizona state law as opposed to whether there was meaningful tax difference. Is that, am I misapplying that? Or, because tax law does things for strange and wonderful reasons that sometimes don't necessarily comport with the common law in a given jurisdiction.
You're correct. Those are two separate arguments, and yes, one is easier than the other.
Well, depending on the day and the issue.
Exactly.
But, yeah.
I'm going to reserve my time, but if there's any other questions, I'm happy to answer.
Thank you.
Very well. Thank you. Mr. Werner.
Morning.
Morning.
My client, Mike Giglio, is here today.
Very well.
Our view of the case is much different than the defendant's. Our view is that this case centers on the argument that this was a sham deal. And in support of their position that it was a sham deal, they look at the Goldstein versus IRS case, which was a case where Mr. and Mrs. Goldstein had a windfall of $140,000 for winning a sweepstakes. And their son, who was a CPA, and some investment counselors suggested that they borrow money in a number of transactions, and then to aggregate all the interest that was going to be paid over the lifetime of the loan, and use that interest as a deduction against the $140,000. So when they filed their tax return, the tax return was looked at by the IRS, not the courts. It looked at by the IRS and said, you can't do this. It's swapping liabilities. And we don't like that to happen. So we're going to reject your tax return. And we're going to tell you you have to pay the taxes. That's not our case. Our case is that the tax returns were submitted to the Internal Revenue Service, and they were accepted. So whatever these guys agreed to was okayed by the IRS, and they said this is not a sham.
So let me ask you about that. Is that the same as finding consideration under Arizona's common law? In other words, what deference is owed, if anything, to the Internal Revenue Service, at least for a time, and I don't know if the audit window is closed now, accepting the returns? That strikes me those are different issues.
Well, the consideration is, as you said, there was an increase in the value or the percentage of we called this case Mike G versus Mike M.
Well, I feel a little better. When I called it, I did a fairly poor job, and I apologize to those involved.
So if I inadvertently say Mike G for Mike Giglio.
We'll know what you mean.
Okay. So we see this as Mike M got the extra 5%. The extra 5% then got a promissory note, essentially. And so he moved up in the priorities of when a company liquidates, who gets the money first. And there was no secured creditor as far as I know. So the unsecured creditors, the lenders, get paid first. So he was put in a position of getting paid first, which he wasn't when he was just a capital investor. They get paid after the lenders or the loans get paid. So we see that as the consideration as he moved up, he got in terms of distribution. In addition, what happened was he got to have more, and he also got which is interesting, in exchange for a recourse note, which he didn't have a recourse, he now gets to have this additional income because of the tax benefits. And he admits, not only in the request for admissions and in the interrogatories and in the record, the deposition, that he actually had the benefit. His CPA used the benefit, and therefore he got a benefit. Now, they're saying that he didn't get any benefit. But he did get the benefit because he increased his capital. They also argue that he didn't use it. Well, that's like buying a car, paying for the car, and never using it, and then you get to go back to the dealer and say, I never used it, so give me back my money. He made his deal. Now, we also don't know, and I don't have really an answer for it, when Kristen then walked away from her percentage of interest, is that still a capital loss that she can take? Because she made an investment, she walked away from it, her investment's still there. We don't know what she did, but it seems that that would be also a benefit that she had. So the idea that he didn't get a benefit is just not correct as a matter of law as well as a matter of fact.
Help me better understand why we, in this appeal, care about whether Kristen received a benefit or not.
I don't know, I told you I didn't know the answer because I don't know what she...
But why would that issue be significant here? I get that you don't know the answer because you don't know what she did with that, but why would that be significant for us to resolve this appeal?
I don't think it is.
Okay, I'm with you.
Okay.
I just wanted to make sure.
But I want to hit this sham issue because I think that that's their burden to prove it was a sham. It's not our burden to prove the negative, it wasn't a sham. We know that the IRS accepted the tax return, so they said, we don't see a sham there.
Well, but along the lines of the questions from Judge Fama, we really don't care, and this is, I read the briefing, we really don't care what the tax consequences of all this are. All we care about is that your client's situation changed because of the agreement. That's consideration. That's the end of it as far as the issue before us.
Well, that's consideration, Your Honor, because we have Mr. Mike M. saying, I got a benefit. He admits he got a benefit. So I don't see how they get away from saying, we got a benefit, but now that we got a benefit, we didn't get a benefit. But it's the sham part that disturbs me. And early in the proceedings, I argued to the other side, you're setting up a sham here, which is a dangerous thing. If you're submitting to the court or to the IRS this sham plan and using it as a part of your tax return, then putting into the public record that it is a sham, shouldn't you be then amending your tax return so that the sham now is discarded and you're redoing the tax return based on reality?
But we don't have any occasion or any need to resolve that issue, whether it's a sham or not a sham. As I understand the briefing, the issue in this part of the case is whether there was consideration or not. You argue that there is, and then isn't that as far as we three need to be concerned? As far as whether it's a sham, that may be bad, but that's not for us to think about.
But if it's a sham, then there's no consideration, but their claim was a sham. And I just think that you can't have it both ways. You can't ask for and get a benefit and then say, I don't want the benefit, and now I'm going to say it's ineffective. So he accepted the benefit of the disallowed loss, which he didn't have a loss treatment for the 2016. But because of the agreement that they made, the special allocation agreement, he then gets that benefit, which he admits taking. I mean, it's in the, like I said, it's a request for admissions in the interrogatories. In his deposition, he said, yeah, I got a benefit.
And then if you get a benefit, there is no sham, correct?
Well, if there is no sham, then we win. because he only wins because he says there's a sham, and therefore there was no deal. But if there is no sham, and the IRS then accepted it, and there's nothing by a court that says that this was a sham and I'm going to disallow it, then in that case, we win the case. We simply look at it as there wasn't a sham, it was a legitimate deal. Everybody signed the agreement. The agreement is enforceable. There's no sham. There's no allegation that there was fraud. There was no allegation there was mutual mistake. There's no allegation that it was not understandable. There's no argument that it was ambiguous. If you just look at contract law directly, here's the SAA. Everybody signed it. It changed their tax liability. They went on their way. They filed their tax returns, and now we're here because they say you can't enforce it. We can't enforce it because Mike M. signed the deal.
Yeah, so what would your argument be if instead of accepting or allocating the loss in tax returns, appellant simply got extensions and hadn't yet filed?
I don't know, because I don't know what happens if a disallowed debt in 2016 is not used in 17. And I think that the rule is that you can use it for 1 year.
From the tax perspective, right?
Right.
And again, we're the common law people. We're not dealing to the extent we're able with the Internal Revenue Code. This isn't a tax court appeal. It is a appeal, as I see it, on, and you used the word sham, I might encourage us all to use consideration, fair consideration, and then certainty of terms. And I understand that you may view those as sort of a proxy for each other, if I'm hearing you right.
They use the word sham.
I understand. And again, offer, acceptance, consideration, certainty of terms is sort of, and setting the UCC aside in the common law world where we are.
I think then it satisfies those elements.
And I understand that. I understand.
It's a plain document that says what it says. And no one's claiming that it doesn't say what that says.
And if we were to find all the elements that were satisfied, we wouldn't need to opine any further. And you would win.
I like that last sentence. That's what I like to hear. We would win. So
I'm just wary of venturing into in issues of sham or no sham. I'm thinking back to my old law school class, the elements of a contract. If they're satisfied, I'm happy.
I agree with that. I think this is an enforceable contract. Everybody took advantage of it, including Mr. Mirshahzadeh. We win. Any more questions for me, judges?
No.
Thank you.
Thank you, counsel. Mr. Meyer, rebuttal.
I agree with Mr. Lerner that, this is a, 2-page contract, and, we've each submitted our arguments, and I think they're, pretty straightforward. It is exactly as you say, the offer, acceptance, consideration, certainty of terms, and those are the issues here, and whether the parties already had those existing rights and benefits, or whether there was something new provided to them in the allocation agreement. We submit that there was not an additional matter of consideration or benefit provided to our client that he did not already have or have access to. And if there are any questions, I'm happy to continue to answer. Okay.
I don't believe so. Counsel, we appreciate your presentation today. We appreciate your briefing. We will take the matter under advisement, and we'll issue a written ruling in due course. Court stands in recess. We're going to stay on the bench while we set the courtroom up for our next oral argument. Take good care.